coming to you live from Las Vegas. This is the CEO legal coach, Acacia Thornton, and today we are talking about how to reduce those legal fees when it comes to your non-disclosure agreements as a business owner. Now, I have a little bit of an interesting look today. We are in the studio filming my Boss from the Beach program, which is ironically or coincidentally about NDAs in business, particularly with employees. So I'm wearing my swimsuit. With a blazer over it. But I was definitely not going to miss this topic today because this is one of my favorites. And I have had so many friends, so many clients and things over the years come to me about NDAs. And the first reaction I have is please stop spending money on that. Please stop spending money in these ways. This is one of the areas where law firms get a lot of your business, or you end up taking a risk when it really is simple. So that's what today is. I'm going to show you three of these things in this context so that you know how to make better informed decisions when and where to spend your money and when and where to save it. So let's dive in. We are going to talk about 3 steps to avoiding NDA legal fees. Some of the action coming at you today is going to include going through what those are. Very quickly, I'll give you a brief introduction as to what is an NDA, just in case you don't know. Quick 30-second tutorial on that. And then we're going to get into those money-saving ways of thinking, because it really isn't a factual situation thing, as I'll show you. It's merely how we think the NDA is versus what it isn't. And when we change this way of thinking, we're able to save a lot of money. And then, as always, there will be a freebie at the end of this. Today's freebie is going to be an NDA, and I'll show you how to get 2 different types of NDAs. And then, of course, an open Q&A for all of you to ask your questions. You'll be able to put those into the chat, so whatever platform you're on, go ahead and find that. In about 15, 20 minutes, I'll be taking your live questions and answering them on the spot to help you all. All right. Oh, who am I? If you are not familiar with me, I am a longtime licensed attorney. I've been in-house for small companies, medium companies, and even Fortune 500s. I'm also a small business consultant. I'm an entrepreneur myself, as well as an award-winning sales rep. And this all matters in the NDA context, particularly because I understand what it is to get out there and need the business, not mess with our customer relationships more than we need to, but also how to make them secure while bringing in that revenue the right way. So this is probably why this topic is one of my all-time favorites. All right, what's an NDA? What the heck is an NDA? NDA stands for non-disclosure agreement. It is a signed document that a party or both parties will be giving information for a particular purpose or use, and that information is not to be shared with anybody else or used for any other reason. This is a really important document because, one, it's free to use. Nobody's paying anybody yet. It's just about, hey, while we have conversations, as we build our relationship, as we sample things together, let's promise to not share this with our competitors. Let's promise not to sell this to somebody else. Let's promise not to use it to make money. I have had a client do that the wrong way before. They went to go look at some technology. The owner of that technology and the way he put together the platform, he had the company sign an NDA. And then my client at the time was like, yeah, we saw it. We realized we could just do that ourselves. So they went and did it themselves. They got themselves sued, right? So what that guy did by having that NDA signed before he showed these guys what his technology was, is he protected his right to revenue for it. He said, this information that I exchanged with you was not allowed to be used that way. You can't do that. I have rights here. You're going to pay me for it. So it could be a great way to get your stuff out of your competitors' hands. Make sure stuff isn't ending up in just keeping your commercial value for your things, but also that you're getting paid for your ideas and your information, not somebody else. So NDAs are great because, like I said, they're free to use. Once you have an NDA set up, you don't have to pay every time you use it. There's no exchange, nothing. And they're super, super easy and simple. Super, super easy and simple. Every single NDA is going to be about these 3 things. This is one of those mind shifts I was talking about. Every NDA is about 3 things: the information that is going to be protected, the standard of protection for that information, and what that information can and cannot be used for. Plain and simple. Every NDA. So it doesn't matter if the information is with your customer. Are you giving your customer information? Is your customer giving you information? If that, who, what is the information to be protected? How that information can and cannot be used, and the standard of that information needs to be protected under. What if it's about your suppliers? Suppliers, same thing. What information needs to be protected? How that information can and cannot be used, and what are the standards for protecting it? Investors. Investors, what are we going to do? We're going to care about the information that's being exchanged, how that information may or may not be used, and the standard of which that information needs to be protected. Same with your employees. The information, you see the trend here. It doesn't actually change what the NDA is designed to do and its core purpose, not disclosing information. That is the same no matter what scenario we are in, which kind of gives us a great opportunity because the situation is something you know best. Who knows best about the standard for protecting your information? You or your lawyer. You know what your information is. You know why you're exchanging it. You know what you want it to be used for. And you know the standards. And most importantly, if you're signing on to do the same for somebody else, like your customers, your suppliers, you're the person who knows if your company can meet those three things for the other side. In other words, who is the expert at knowing the core components of what an NDA is about? You are. As the business owner, as the relationship driver here, you know what the information is going to be exchanged. You know what it's allowed to be used for, and you know the standard of which it needs to be protected. And if you're the one offering those, you're the one who knows if you can comply or not. So we're going to get a little bit later into some stuff regarding your lawyers. But one thing to know is that at the end of the day, the lawyer cannot do their job without you. What a lawyer brings value to is one, they've gone through NDAs before. They know what should and shouldn't be there. And maybe you're not familiar with that yet. That's okay. But your lawyer doesn't understand things the way you do. So it's also going to be important that if you choose to go with a lawyer for any reason, you have the answers to these questions prepared to maximize what you're getting out of that lawyer and making sure that you're not spinning your wheels with extra things. But do know that once you get a grip on these things, you know better than the lawyer, which is our saving tip number one. Not every NDA needs to go to a lawyer. We talked about how the scenarios of your customers, your suppliers, your investors, your employees are all about those three things. So if you have a good grip on what these are and how to put them into your NDA, you don't need a lawyer. Okay. You are the subject matter expert. But of course, there are times to get a lawyer. When would you need a lawyer? See, the lawyer is not going to come in and say, this is what the law is. You're coming to a contract. When we have a signed contract in any business, we are saying this is what we agree to above and beyond the law. I'll give you an example here. When I go into business with a client, I don't put into my contracts with them, you will not murder me. That'd be a weird one to put in a contract, right? Well, for one, hopefully it doesn't come up. But two, there's already a law for that. I don't need to write that down. You don't need to write that down. We know it's against the law to murder somebody. So why then do we write things down in contracts in business? It doesn't matter what contract, your customer, your supplier, your vendors, all of it. Every contract is being written down because that is what you are agreeing to above and beyond the law. And I mentioned this in the NDA context because the lawyer can only tell you what the law is. If you want to agree to something above and beyond that, that is your choice. And that's what an NDA is doing. We're saying we're going to protect the information that is not otherwise protected under law. You get to agree to that. It helps your business. And that's why NDAs are so important along the way, is because without an NDA, the law may not be protecting your information. It might protect things like intellectual property, but it's not going to protect your customer lists. It's not going to protect other types of things without that NDA in place. So know what your lawyer knows and know what you know. And once you get better understanding of what is going into your NDAs, you can stop sending them to lawyers when you don't need to. But that's going to take us into this next level because I can already hear you being like, no, it's totally different. I'm telling you, Acacia, it's different. I know, I know. Let's talk about the $100 customer versus the $100,000 customer. I love this one because I have a friend, CFO, sorry, Chief Financial Officer for a medium-sized company, very successful and well set company, and they don't have in-house attorneys. They pay for things as needed. And he would tell me that as he would get the NDAs into him, he would choose to send them to their outside counsel. And I was like, why are you doing that? It's the exact same. And he's like, well, this is a little bit different. That's a little, it might become this. It might. I was like, take a step back for a second. When you have $100 customer, like whatever your pricing is, right? Let's just say it's a low dollar amount, something that you're just like, whatever, happy to take the sale, but not really thrilled or excited about it. Just okay. You're going to just send them the paperwork and you're going to move on. You're not going to spend the time to spend the $100 customer document to a lawyer. It's a $100 customer document. Now, a $100,000 customer, you might be like, hey, we need to get this right. I want to do this right. And so what you're going to do is you're like, this one's more important. This feels a big deal. Let's send it to the lawyer. Now, as we just mentioned, every NDA is about three things: what information is being exchanged, the standard that information needs to be protected at, and the use of that information. It is very possible you're giving both the $100 and the potential $100,000 customer the exact same information, particularly upfront before they've signed the contract with you, right? You're going to tell them what your company is, walk them through a demo, whatever that sales process is for you. You're going to treat them the same because you don't ultimately know how much they're going to spend. Sometimes what you think is going to be a big client turns out to be a small one, and sometimes what you think is going to be a small one turns out to be a big one. We don't actually know. We get excited. Oh, we get excited for the big customers. But truth is, until they sign, we don't 100% know. And that's when the NDA happens. The NDA happens before that money and deal is set. The NDA is about the information. So your $100 customer is probably getting similar to, even if not identical, information as your $100,000 customer, right? The information is the same. The way they're allowed to use that information will be the same to assess whether or not they're going to enter into a business relationship with you. And the standard that you're going to want that information protected at is going to be the same. In other words, the content of your NDA doesn't really change between the $100 customer and the $100,000 customer. But if you have the $100,000 customer, that's the one you're going to send to a lawyer. It's the same, very same or very similar, right? Just little tweaks between the differences. And then now let's look at the other side. If something goes wrong, who is more likely to breach your document? A $100 customer or a $100,000 customer? The truth is, it doesn't matter who ends up abusing your information. It doesn't matter who gives it to your competitor. It doesn't matter who sells it or puts it on the internet. The harm is the harm. The harm to your company is the same if that information gets out there and into the wrong hands or gets misused, whether it was a $100 customer who did it or a $100,000 customer who did it. The harm and pain to you is the same. The risk to your company is the same. It doesn't matter how much that customer may or may not be spending with you. And well, it's not always a guaranteed. Whenever we have customers that tend to spend more, higher spenders, usually, not always, tend to be more established. More established companies usually have better data security. They usually have better policies. They usually have better contracting in place. And they usually have insurance, meaning your $100,000 customer is less likely to have the types of voids in their business processes that are likely to lead to a breach. And in the event that there is one, they are the ones more likely to have the resources to help you. The $100 customer, however, probably doesn't. So if we look at it from that perspective, your $100 customer might actually be your riskier relationship on an NDA than the $100,000. But because in the beginning you were so excited about the potential $100,000, you actually went and sent that one to the lawyer. The truth is, they're the same type of information going to both of them for similar uses. And should either of them breach, it doesn't matter who breaches, that breach is going to have the same type of impact negatively to your business. Meaning, both of these are the same. And the real riskier one is actually the company that has fewer policies and procedures in place to protect you and respond should something go wrong. Yeah, that one is another one of those shifts. We get so excited about where the deal is going, where the relationship is going. That does not matter at the NDA level because it's about the information, the standard to protect it, and how it can be used. So that is our money saving tip number 2 is don't repeat a sunk cost. Don't repeat a sunk cost. Don't be like every time the deal is over $10,000, we send it to a lawyer. It's probably the same type of stuff. If they are similar in the information, the standard, and the use, send it to the lawyer once or get your help from a legal coach once. Don't keep redoing it or make sure you're learning what you didn't learn last time. Make sure you're getting a value for that. Don't blindly resend them because that's what my friend, the CFO, was doing. He's like, well, this one's different. This one's different. And I'm like, they're not really different. You're repeating a cost blindly, and it's actually becoming a sunk cost because you get no value for it. You get no repeat value for it. And NDAs are so important and regularly used in business. You're probably going to start signing multiples a day once your company really takes off that you don't want to be doing that sunk cost or blindly doing things. So that's another great way to save money on NDAs. All right. Now, the third one is to start strong. The last two, we have assumed you already have an NDA template, and we've done that. But it is important to start off correct. The template does matter. It does matter. And and the template is what you start from, right? We talked about, well, you're always going to have to change the company's name, right? If it's the customer's name, that's going to change every time. What information may or may not get exchanged. Sometimes you have to update that. Sometimes you won't. The standard, and then that use case. Those are the things you might look to change from time to time, but you don't need a lawyer to do that. So if you have a good foundation of a template in place already, you have a great, strong foundation to avoid legal fees. And it does matter, not just for that, but it matters for a few reasons that we're going to get into here. We're going to go into 3. The first is red lines. If your template is not designed for your use case, it's going to get heavily redlined, which is a time waster, delay signature from your customer or your supplier, and that's going to add to legal fees because what the heck are you supposed to do with those? So having the right template from the beginning matters. And when I say the right template, what I mean is for your scenario. There is a competitor. There's one of those like do-it-yourself legal companies out there where if you search for like a free NDA template, they let you go through the process and get one. And I did this because I wanted to see what resources were out there to my clients, and I got that NDA template. It was horrible. Like, I don't even think I'm legally allowed to say how bad this thing was. It was bad because it was trying to be a little bit of everything, and therefore it did nothing correctly. Nothing was adequately addressed on that NDA. And because it was trying to do other things, it sometimes had terms that if you were trying to use it for one of the other scenarios, they were conflicting or they would cause problems and possibly even cause the whole thing to be illegal. And I was like, that is not how you do that. It's really important, and I'll show you here in a second. So don't worry, we're going to dive into this a bit. To pick the right type of situation and dynamic for your NDA template to start with. Okay, that's really key there. And so the red lines, those missing terms I just talked about. So you want to have all the right terms for that type of dynamic, conflicting terms, and post relationship. This is also really important, especially in an employee NDA. If you have one as a boss with your employees, because you don't want it to end when the employment ends. You don't want them to be able to just now go work for somebody else like a competitor, and now the NDA is over, so your information is no longer protected. No, we want that to survive after that end of employment. That's important there. But that type of dynamic would not exist in other types of NDAs. So being aware of that. Compounding every other NDA. So, one thing we've talked about in all of our scenarios today thus far is this versus that scenario. The truth is, in time, you're going to have a lot of NDAs with your customers, and you're going to have a lot of NDAs with your suppliers. And if you're out there trying to get investment now, or you do every few years for different phases of your business, those are going to add up too. Every time you share your information, there's a risk it could go wrong. Not intentionally, but just the risk something might happen. There might be a data breach of some sort. Somebody just might be forgetful. A lot of breaches don't happen intentionally, they're accidents. But now, if you have 100 customers, you have 100 ways that could happen. And if you have the wrong NDA template all of those times, that could compound very quickly. Because what often happens in business is a breach is going to happen in one of two ways. It's going to happen directly with the other party, something unique to them, like they got hacked or something. Or it's going to be something that affects the entire industry as a whole, like the FTC's recent ban on non competes. So when that type of stuff happens, it's going to affect all your NDAs in that scenario. Or they're all going to have the same weakness. They're all going to be misaligned. And you're either going to have to go fix every single one of them, or you can know that you started off with the correct type of template from the beginning and avoid all of that. So it's another way to save you time and money. Now, I did promise you we were going to look a little bit into how do you choose that NDA template wisely. Now, do know I offer a free NDA template for business to business relationships. I'll show you where that link is here momentarily. And when I am done filming the Boss from the Beach program, that is going to have a free NDA for the employee employer area. And they all will come with a customization guide so you can make sure they are specialized for your scenario. And they're going to give you the how to's, talk tracks, any other templates you might need. Things like that are going to be built into the scenarios so you have everything you need. Now, choosing wisely is important. So the top two really come up in the business context, which you being a business owner is what you care about. So business to business dynamic. This is a different dynamic than we have with our employees or in our personal lives. So this is usually between an investor, a customer, a supplier, and the truth is they're all kind of the same. An investor is a supplier of money. A supplier to you are the customer of the supplier, and the supplier, you are their customer. So, which means your customers, you are the supplier, and you supply to their customers. So, the truth is, these are all very similarly related dynamics, which means you can use a business to business NDA. So, if you have one of those scenarios, know that a business to business NDA is what you are looking for. And there are one sided ones and there are two sided ones. I am a big proponent they should always, always be two sided. And here's why. When do we ever have a relationship that only one side ever shares anything? It's not really a relationship, really, right? It's not. And in business, the goal is to start in one place, but eventually both parties are going to be collaborating. Both parties are going to be talking and sharing. So you might as well just start in the beginning knowing that. So I'm a big proponent of the mutual NDA, and that's the one I give away for free. But every now and then, there might be a reason that only one side shares something, and the other party doesn't even want to make promises back. Because that's the key about a unilateral, is that it's one-sided. Only one party is allowed to share information, and only one party is making promises to keep it protected and use it the right way. The other party washes their hands entirely, is what makes it risky and why I don't advise it. But if you ever do need that, you can look for a business to business unilateral NDA, is what that's called. Okay, so those are two types of business to business NDAs. The next is your employee employer NDA. Obviously, when you have somebody who is in house working with you, has an intimate connection to the knowledge and awareness of your company and your information, but then might leave someday, you want to have a different type of dynamic there. It is also unilateral. Only one person is sharing. The company's information is being accessed by the employee. The employee doesn't give you their confidential information back. That's not there. So it is a type of unilateral NDA, but it is specific to that employee-employer dynamic. Because a few things going on there. Again, that intimacy of their access, they're going to see a lot more of your company and how it functions, how it works, what its plans are, where it's going, where it came from, than you would if you were in a business to business dynamic. You also need to make sure that employee employer situation is addressing not just their current employment, but also what would happen in the future as they may depart. So you're going to want a specific employee employer NDA for that. And those are always going to be unilateral NDAs. Do not use a mutual NDA for that. So those are the two key areas in business and how you're going to want to choose your NDA template wisely so that you're getting the best value and avoiding all those headaches that could come along, particularly the ones that lead to legal fees. But do know that there are other types of NDAs out there. Of course, you hear about them in celebrities when they're dating people. You might have one in if you're doing medical stuff or have patients or you are the patient. And there's a few other areas in the world where we might have personal situations with NDAs. So do you know that the two at the top are not the only NDAs in the world, but they are the two that relate to business. All right, so I promised I would show you where and how to get that free NDA. If you need a free business to business mutual NDA, this is where you can get it. My website, ceolegalcoach.com/free NDA template. And then, like I said, coming out here shortly, once we're done with the Boss from the Beach program, we're also going to have that employee employer NDA template available for free. Both will be able to be ready to be used in under 10 minutes. You'll have your customization guides. I will even read them to you so you don't even have to read the darn things. All of that will be available to you. So you can have a great launching point from there. Now, Q&A. I love it. All right, so I already see stuff coming in. I know, guys. I know. Okay, so go ahead if you do have any questions about this topic. You can put them into your chat right now. I'm going to start answering them here on the spot. But do know if you're watching this after the fact, you can always put your questions in the comments below, and we'll get to them as we can. Or you can reach out to me at the website ceolegalcoach.com. All right, let's see. What do we got here? I have already shared information. And I didn't have an NDA. Is it too late to use one? It is never too late to get an NDA into place. It's never too late to get an NDA into place. What is important though is that you need to make sure the effective date of that NDA goes all the way back to when you first shared information. So you're going to backdate the effective date. That's the effective date. Do not lie about the date of signature. Don't do that. If the template you're using doesn't separate effective date, make sure you add that because that's key. When you don't have an effective date listed on a contract explicitly, like, hey, this NDA starts on this date, or the effective date of this NDA is this, what happens is we create a default, and the default is the date of the second signature. So your signature would be now, even though you gave information back then. So we want an effective date of back then. So, but yes, you could always get NDA into place at any point in time. If it's with your employees and you didn't do one up front, you can even do one when they depart. There are certain requirements you need to meet to do that. The Boss from the Beach program walks you through all of that, but be aware that there are a few extra things you have to do if it's after they have started employment with you. But anybody, you can always go on with suppliers, customers, and so on after the fact. That's not a problem. Yes, there's no time frame for that. Is an NDA the only way to protect your information? So, two parts to this answer. Most of your information is not protected under law. It is not protected under law. Stealing it and abusing it, like certain intellectual property, okay, the intellectual property laws will protect that. But everything else about your business, your ideas, your customer list, your finances, anything, once you share it, if there is not a pre-existing law that protects it, which most of the time there is not, you're giving it away without protection. So it is important to have terms of confidentiality in place. Now, an NDA is the primary, most common used way to do that because it is just about that non-disclosure. It's just about AKA confidential information, right? So as you list that information, this is what we're going to keep confidential. This is the standard you're going to keep it confidential at, and this is the way you are and are not allowed to use that. So an NDA addresses just that. It doesn't address anything else, right? It's not going to address your supplier agreement. It's not going to address your customer agreement when you come down to what products and services are being exchanged and timelines and money. That's on a different document. So NDAs are the primary number one way to get terms of confidentiality in place so that your information is protected. And what's great about them is because they don't have any of those other terms, you could do it so early in the relationship. You could do it on day one without even having a discussion about the product or service yet. Be like, hey, let's just sign the NDA now. That being said, once you enter into a customer or supplier or a vendor or investor document, that document might have terms of confidentiality in it. So, and those terms of confidentiality would only relate to one, the date, that effective date of that, but also the information specific to that part of the deal. So let's say you exchanged information about products A, B, and C because you weren't totally sure, and they picked product A. Well, only product A's information is going to be protected under that contract if there are terms of confidentiality in that contract. Products B and C weren't included in this document, so that stuff never got protected. So this is my long-winded way of saying NDAs are the easiest, the fastest, the most upfront way to protect information. But they are not the only types of terms of confidentiality that do exist out there. But the other ones usually come after the fact or when other situations are involved, like the money exchange or product exchange, and it may not address everything. So NDAs are the one that is most commonly used in business. I have worked for clients that would not even let their sales team have a customer conversation, not even that initial conversation with a customer without an NDA in place. So NDAs are the most common, but they are not literally the only way. Good question. It's a good question. Let's see what other questions we got going on here. If I do have to reach out to a lawyer, how do I pick the right lawyer? Yeah. I would say, what are your goals? Right? If you're watching this, you're probably looking for ways that you can take some of this on yourself. And as mentioned before, you are the subject matter expert about majority of what changes NDA to NDA. So having a lawyer or a legal coach or somebody else help you create that initial template might be a great idea. That way you know. But you also want somebody who's not just going to be like, okay, here's a template. You want to be able to learn from them, know how to go through some of those steps we talked about. Okay, now I want to know how to just update the information on this. I want to know how to change the use case on this. Those things. You want to have somebody that will allow you to ask questions and not hold things back. A lot of lawyers and a lot of law firms, not all, but a lot of them, that's their business. They need your business over and over and over again. And so leaving you blind, leaving you ignorant, leaving you feeling insecure is part of their business model. Now, other types of law firms, however, sometimes are just like, we love having you as a customer, but NDAs are so simple and easy. We actually, as a law firm, don't like spending our time on them, and so they might be more open or willing to help you. But I would look for a lawyer that's going to have the dynamic with you to help you move forward the way you want to move forward. I legal coach right here at group coaching. I also have my do-it-yourself packages where you can learn these things your way on your schedule, only to the extent you need to get practical guidance and make that informed decision, right? Do you need a lawyer for this step? Yes or no? If you don't want to use a lawyer, here's how you're going to do it. If you do, here's how you're going to do it. So it's more about giving you the informed choices when and how you want that and finding a law firm or lawyer that's going to do that. I will admit legal coaches like myself or contract specialists are more likely to share, more likely to guide and help you become self-sufficient at them. But you never know it, and that's what I would look for based on what your goals are out of the scenario long term. So what really is the value of a lawyer? Okay. Well, for one, the lawyers have seen a million NDAs, Right. I have been doing NDAs even before I went to law school. So I think the first NDA I saw in my life was probably close to 20 years ago. So when I started redlining them. So I've seen everything, or at least it feels that way. Right. So I know not just what to look for, but how to quickly fix it, how to quickly get off the paper, what to put there instead, or how to tell my client, like, they put this on there. This normally isn't there. So I think they're trying to do this. Those types of things I can get through very quickly because I've seen them all. Same with lawyers. A law firm is going to have that experience. You're probably just starting out looking at NDAs for the first time. So we can learn from people who have more experience. But there is a difference, again, back to who is the expert at these things. Who's the expert on the information? You are. The lawyer can tell you how we maybe want to phrase that, or maybe, hey, here's what the other side is trying to do. Oh, that's missing. Let's put that in. The lawyer is going to do the reading and filling those gaps, but you're the subject matter expert. The lawyer can read an NDA and tell you, hey, here's the things you may not be compliant with, but you first have to tell the lawyer, here's how we handle stuff. Here's what we do and don't do. So the real value of a lawyer is they're reading it. They're going to read it and they know how to change it quickly and easily. You're maybe one who does or does not want to read it, or two, doesn't care to learn how to change it. So that's the real value of the lawyers when it comes to NDAs. Other types of business contracts are going to have a different value structure. But NDAs, because they're always about such a limited space, we can really make it that simple. Yeah. But I will be honest, a lot of law firms just kind of have a checklist. They go through that checklist, and I've even seen law firms make assumptions about their clients. They just assume clients have a policy for this or a policy for that and a procedure for this or meet certain data requirements. And I'm like, but they don't. Did you even point it out to them, or did you just throw it in there because it's on your checklist? You're causing your own client to breach the NDA from day one. They are the ones who know if they can meet the standard. They are the ones who know their obligations. Like if they have information, it's personal information, and they got that from one of their suppliers, they know the supplier contract. They know that. The, the client does. You, as the business owner, know that, not your lawyer. So your lawyer might actually cause error sometimes by making assumptions. So it's really important to have that open dialogue and doing that. But that's how the balance of what a lawyer does. They're not afraid to read. They're not afraid to write, and they're not afraid to redline, where you might not be so comfortable or willing or wanting to do those things. Yeah. Difference between a lawyer and a legal coach. Yeah. This is a great one, right? So, as a legal coach, what I do is I coach my clients into success, whatever that is. Sometimes it's a deal, sometimes it's next phase of their business. So, we're coaching them, and then we're having the contract that does that, that secures that makes that deal bigger in all the ways we talked about. Where when you have a law firm, and I don't just give you the contract, right? I'm going to make sure that you know what you need to know about it, you're comfortable with it. And then if there's questions that come up after, like some of my clients sometimes get templates from me, like we want to update this template because we're moving forward with our business, they can ask those ongoing questions. They don't have to be like, oh, is this a $250 an hour question? I don't know. My goal is to get my clients to be confident and self-sufficient and know that I'm here to support that, as opposed to me doing the work for them blindly, which is what law firms do. Law firms, you can be like, here's a document, and I'll be like, okay, blah blah blah, here you go. Some law firms will take the time to walk you through it, some won't, or you have to pay for that. They also have a different pricing structure, usually by hourly, but sometimes flat rate. And that flat rate is not about making you feel good. That flat rate is not about you learning how to be sufficient. That flat rate is hoping you'll come back and need that flat rate again. So it's a different approach with a different goal. Not every company wants to learn. Not every business owner wants to know how the contract makes them more money or look for those opportunities. They rather just be like, I need this document. Let me go pay somebody to give me that document. Somebody's redlined that, send that back out. Blindly done for you, right? Law firms are going to be great at that, done for you. Don't worry about it. We've got it. Duh. With me, there's going to be more dialogue. With coaching, there's usually the dialogue, the question and answering, and sometimes the learning on how to be self sufficient. So those are the two big differences between a legal coach and a law firm is how you interact with them and the overall goal of that relationship. Mhm. Good question. Um, what happens if somebody breaches an NDA? All right, okay. I've got a few videos about this on YouTube and also like both the boss from the beach and my happily ever after program. This is what they walk you through. They literally walk you through what to do, action steps, templates, all of that. But the quick answer is first off, if something goes wrong and you don't have the NDA in place, you almost have no ability to do anything. I'm going to repeat that. You almost have no ability to do anything. You can't step in and stop it. You can't recover damages, not unless it actually violated a law. Gone as far as violating the law, you have no action available to you. None. No recourse. And that's why NDAs are so important. Where if you have the NDA, here's what you can do. You can take steps to stop that breach, mitigate the breach, get it under control, and then you can go into phase two, which is recovery. What were all the costs that were involved? How much money did you lose? Let's go get that money back. Those two opportunities of stopping and mitigating the breach and then recovering are not available to you under any other areas of law, generally speaking, just for simply disclosing or misusing information. Yeah, outside of the IP, intellectual property context. Mhm. All right, guys, we've definitely hit time. I see a few more questions coming in. So what I'm going to do is I'm going to go ahead and put those into the bottom, into the comments below. You'll find the answers to that. I see one about a little bit. Okay, how can you save more with an NDA? Okay, yeah, I can give you guys a little bit more details, and then of course I will put the links to both of those free NDAs in the stuff below.